Daniel Mail here again, covering the closing arguments now in the case of the Alexander brothers. Again, Orrin and Tall Alexander were luxury real estate agents alone. Orrin's twin was in the family security business, Kent Security. They are accused now of 10 counts, not 12, 10 counts. Government did not proceed with two of them, 6 and 7. And there's now 10 counts in the federal sex trafficking case. I'm going to go over some of the arguments here today. Again, like a broken record, not defending anything that they have done personally, not saying they are good people. That's really not relevant. I'm exclusively covering the federal trial. Perhaps in the state trial, cover as well. Seems to be that there's people that are interested in it. I'll pay attention in some of the civil suits. I think the media aspect of it is very interesting. There are many interesting aspects of this case, but this is not a trial of them as individuals. It's a trial based on the 10 counts, if they're guilty or not guilty in a court of law by a jury of their peers. It's about the only thing I'm interested in at this point here. I've already decided the first time I ever heard about anything they were doing that I found much of their lifestyle to be absolutely disgusting and a lot of their conduct to be gross. But that really has nothing to do with the 10 counts that they're facing. And I just wanted to go over some of these points that were brought up by Assistant U.S. Attorney Andrew Jones and others. It was really fascinating going through the transcript from yesterday as things have materialized and really, preparing for the end here. When Andrew Jones presented the specific text message, it was in a group and it said, quote unquote, try to orgy them out. Every single time that Andrew Jones read it out loud, according to the transcript, he dropped the word try. And defense attorney Howard Srebnick, who's representing Alone, he said, quote, as if the word orgy means our word, them. That's what the government is defining orgy. Our government defines orgy in the dictionary of their dictionary means rape, or our word, I should say, for YouTube. 6 times is a choice. A slip happens once, but it says everything about how the government was approaching this case. It's not a prosecution shows. It's a prosecution of what they want the jury to believe it shows. And it's really not even a discussion about whether or not Orrin, Alone, and Tall were terrible to many, many people, business, women, whatever it might be. But the real question, again, does what they did satisfy the specific statutory elements of the specific crimes charged? And the government has been remarkably creative about not answering that directly. So Andrew Jones said the following, quote, at the start of this trial, we told you the defendants masqueraded as party boys when really they were predators, crushing evidence that the defendants committed an array of federal sex offenses. They used a consistent playbook to lure, isolate, and R-word their victims. And notice end quote. And notice he uses the word playbook consistently. It's designed to make the jury see a pattern where the law requires proof of specific elements on specific counts. Pattern evidence is powerful, and it's also dangerous when it substitutes for proof. The most important thing that Jones said, the one that got an immediate objection, was, quote, it's not only about pimps and prostitutes. Federal sex trafficking, the law, is violated whenever a defendant knows he will give a thing of value to a victim to cause that victim to engage in a sex act using force, fraud, or coercion. And Deanna Paul immediately stood up and objected on grounds that Jones was misstating the law. Judge Caproni said, overruled, I'll charge you on the law. But Deanna was right. Jones dropped the word commercial. The statute says commercial sex act, not sex act. It's not a paraphrase. It is a substitution with what he was trying to do there in closing arguments. Under Jones's formulation, any sexual assault where the defendant ever gave the victim anything, a drink, a hotel room, a seaplane ride, becomes federal sex trafficking. It's simply not what Congress wrote. It's not what the statute says. And then Andrew Jones goes on to say, the recreation or entertainment theory goes, quote, I expect that Judge Caproni will tell you any tangible or intangible thing of value, including, for example, recreation or entertainment, meets the definition so long as it has subjective value to the person who is receiving it, including the victim. And then he applies it to Hamptons house parties. The most obvious example are the homes in the Hamptons. Another thing is travel, flights, whether commercial, private. All of them are valuable. For that matter, so is a ride on a charter bus. So if someone took a bus from Manhattan to the Hamptons and there's an allegation of SA under what Jones and the prosecution are arguing, that would constitute a federal crime. It's never been that way in the history of this statute to be what's normally prosecuted under a state court to all of a sudden rise to the level of a federal crime. And again, this is not even saying, did it happen? Did it not happen? It's just a fundamental change in the role of the federal government and federal statutes and how these kinds of cases are handled. So now a charter bus ride can then lead to a commercial sex act. A seaplane could lead to a commercial sex act. An invitation to a party could lead to a commercial sex act. And the word commercial has been completely emptied of meaning. And he's also saying that the intent, the sex no matter what theory, according to him, what was in the defendants' minds when they offered the women valuable things? At this point, it cannot be clearer. It was sex. The defendants are not generous. It's also important to note that the quote-unquote good guy evidence was completely excluded from the trial. So when Alone's ex-girlfriend, Danielle Epstein, testified yesterday, she was not allowed to even say that she lived with Alone. So what you have is a version of the Alexander brothers that's completely devoid of any empathy, love, compassion, completely unable to see anything outside of the scope of the accused. But the prosecution is allowed to create an argument of a pattern. Now, in the case of the Alexander brothers, if they slept with thousands of women, you have 11 or so who made claims in this case. But the way that it's being presented to the jury is that 11 out of 11 women are alleging that they are victims of their depraved behavior, not 11 out of 2,500 or whatever it might be. So if you understand the scope and the limiting instruction when it comes to what the defense is even able to say, it changes how people see the behavior. Not condoning any negative behavior or illegal behavior, just calling balls and strikes here. Then the government proceeded again to the blog. The blog, which was let in, it was allegedly operated or created by some of Oren's roommates, not Oren, not Alone, not Tall. In 2008, the internet was really taking off. You had all sorts of crazy things online then. And again, this blog is particularly gross and disgusting. Jones read 2 posts at length. Excuse me in advance for the grotesque nature of this, but from April 2008, how they wake up. Imagine for a minute that last night you and your boys ran train and clowned on some hoes, straight up muted them out and maybe got it on video. We wake up refreshed, energized, confident, happy, content, laughing all the way into the night, repeating quotes from the night like spread 'em, B word, spread 'em. Post 2 from April 2008, it's not our word if. It's not our word if she's sleeping. It's not our word if she doesn't remember. It's not our word if you use her tears as a lubricant. And then Jones says, quote, somebody might try and tell you this is just locker room talk. This is how you know it's not. It's completely disgusting and repugnant. Nobody would defend that this is normal behavior. I mean, these guys are, whoever wrote this is clearly disgusting. But there's a legal problem here, and the blog is from 2008. It's not authored by Oren, Alon, or Tal. They might know someone who did it, but that doesn't mean that they did it because they didn't. Can a blog from 2008 be used by the prosecution as proof of specific intent on counts from 2009, 2011, 2012, 2014, 2016, and 2017? There's no evidence that the Alexanders even visited this blog. They just knew the people who had run it. So the government is taking a massive leap in saying that this blog that one of Oren's roommates ran is somehow some sort of manifesto for the next decade of their lives. Judge Caproni went as far as to actually compare them in the sense of to Al-Qaeda, with this being Al-Qaeda jihadi manifesto and material that's admissible. So the prosecution took misogynist internet content and painted this as a character portrait for the Alexander brothers. And again, not defending them as good people, but it's important to note that they also are not allowed to bring in any of girlfriends, any of their other friends who did not have this experience, because that would be under good guy restriction. Mark Agnifilo, famous coming off the Diddy trial, one of the defense attorneys for Oren, he raised the issue that the government is asking the jury to infer guilt on specific charges from that portrait. He raised this repeatedly because the government was saying, how did you feel, which was designed to get witnesses to characterize the defendants as R-worders, not to prove elements. Judge Caproni, the court, not sympathetic to that. So the government called 11 women that were alleged victims. Jones described them as strangers who described, quote unquote, striking similarities. Here is what cross-examinations actually showed. Katie Moore from days 2 and 3 testified about being assaulted by Tal in Manhattan. Initially failed to disclose she had taken Molly, MDMA, that night. Said she wasn't asked. Then she had provided Facebook messages about it. So that inconsistency was put forward. Her memory had, by her own admission, quote unquote, improved over time. I'm not sure how that happens, but think about it. She changed her Facebook profile picture to a photo from that party shortly after the alleged assault. She testified to calling her boyfriend Nicholas at 5 a.m. after the incident. But her close friend testified to his knowledge Moore did not tell Nicholas about the alleged assault until Monday, days later. Leveroni, this friend, also testified he was hearing about her Molly use for the first time in court. He had not heard about it at the time. There was no medical evidence, no drug test. AUSA Jones responded in summation, delayed disclosure and inconsistency are consistent with trauma. That might be true, but potentially unclear patterns is not a substitute for proof beyond a reasonable doubt. Maya Miller testified about being R-worded by Tal in the Hamptons in August of 2014. Invited via Instagram, she viewed the trip as a once-in-a-lifetime opportunity she couldn't afford otherwise. Tal texted her to come in saucy and asked for pictures of her and her friend. She testified that Tal followed her into the shower and forced himself on her while her friend was in the bathroom. but she never told her friend about it, and her friend didn't realize. Defense called Chef Daniel Drozdov, who drove Miller and her friend from the Hamptons to Brooklyn. Drozdov described the goodbye with Tall as pleasant and the 2-hour car ride as talking nonsense, women asking about nightclubs. Said he never saw the Alexanders with drugs. And the government challenged him on cross, and he admitted he had no specific memory of either girl giving a hug, contradicting his direct testimony. Government introduced a stipulation of his prior statement to that effect. Then there's Bella Koval. She testified about Labor Day weekend 2016 at the Hamptons. She initially, according to her account, refused to go on the boat on Sunday, September 4th. Defense showed a video of her, Allison, her friend, and one of the Alexander brothers on a dinghy going to the boat. She then said she felt she had no choice. Claimed to have been paralyzed after being drugged, unable to move arms and legs. Yet hours later, walked downstairs, waded through water, gone onto an inflatable boat without a life vest with her alleged assailant. Her recollection of events was repeatedly refreshed by photographs during direct, suggesting her initial memory was incomplete. Claimed to have a detailed timeline she turned over to the government. The prosecution said they didn't have such a document. Denied believing her friend Susanna was sexually assaulted, appeared to contradict agents' notes. And her most quoted line is, quote, "The memory that remains clear 100% is the R word and assault that happened that weekend. Everything else I don't have 100% clear memory of." So she remembers every single thing, apparently, about what's going on, what happened in that one moment, but nothing else from the weekend, as things didn't necessarily make sense. Make of it what you will here. We're going to break this into several parts because some of it gets a little bit more detailed, and I want people to be able to pick and choose what they want to listen to. So this is it for part one. Part two will drop very shortly.